Hey everyone, Eric Rodabois. We're gonna do a quick 5-minute video talking about the law of intestacy and unfortunately going through a really sad fact pattern. So husband and wife, they've been married for 3 or 4 years. The wife is pregnant. Husband has some health problems, but not serious health problems, mostly heart disease. And he goes for a jog, jumps in the pool, and his wife finds him floating in the pool, and the doctors say he had a heart attack. And super tragic. She was 6 months pregnant, and unfortunately, they didn't have any estate planning done. So no will, no trust. And then when we talk about estate planning, we also look at titling your assets correctly, making sure your beneficiary designations are done, and having advance directives. So what I'm gonna do in this video is we're gonna go through each of those, and then we're gonna actually talk about what happens if you die without a will. So first things first, what's a will? We call it a last will and testament, not to be confused with a living will, which I'll talk about in the advance directives. Last will and testament is just like what you see in the movies. You name an executor, you name your burial instructions. If you have minor children, you name your guardianship instructions, and you say where you want your assets to go. Now, what we've done in modern estate planning is we've tried to make the will as simple as possible because that could become a public document, and a lot of people don't want their personal information being made public. So what we do are trusts. A trust is where I create this trust, I put my assets in the trust has a trustee, the trust has beneficiaries. So for me, I own my house, I put it in my trust, I'm the trustee, I'm the beneficiary, everything stays the same in the eyes of the law. I can still get homestead here in Florida, but then something happens to me, whether I'm incapacitated or I die, then there's a backup trustee, and then once I do die, there are instructions for where I want my assets to go. And it can be very simple, like I want everything to go to my wife, or it can be very complicated. I want this to go to a church, this to go to a charity, this to go to my mom, this to go to my godson, this to go to my spouse. Now there are some other considerations like the spousal share, but we'll talk about that in another video. Then we do what are called advance directives. Advance directives are for while you're still alive. So the three are the power of attorney. So the idea is, let's say I'm in a coma and I need someone to go talk to the bank. Well, the bank's not gonna just talk to someone who walks in and says, hey, I'm representing Eric. They're gonna need to see something more. So we have what's called a durable general power of attorney. Now, what's interesting is we used to have springing powers of attorney, which would say, if I'm incapacitated, then I want this person to be my power of attorney. But Florida did away with those, too complicated, too hard to say if and when. And so now you create the power of attorney and it's effective from the minute you sign it. The second one is the healthcare surrogate or the healthcare power of attorney. That one is like it sounds, I'm giving permission to somebody to talk to the doctors on my behalf if I can't speak to them myself. And the third is the living will, which is also called the do not resuscitate or the advance directives. Basically, I'm going to give instructions, and it's not one size fits all. And it could say, in the event that I'm incapacitated, I want this person to make the decision. Or in the event that I'm incapacitated, I do want life-sustaining procedures. Or the event I don't want life-sustaining procedures, right? And so we put those in writing, and so we can make sure that that our wishes are carried out. Now, all of that's really nice, and that should all be done. I mentioned earlier beneficiary designations, basically anything that's an account, a bank account, a stock account, life insurance, anything that's at a financial institution, you can have instructions, which is just paperwork you fill out ahead of time, that will say if I'm incapacitated, if I die, I want my 401k to go to my wife, or to my parents, or to whoever. Or in my case, I have all of my beneficiary designations going directly to my trust. So my 401k is in my name, but then it says if I die, I want the 401k to be paid to my trust, and then my trustee, my successor trustee, will then follow my instructions and carry out my wishes. Now, if you don't have an estate plan, what happens is the law of intestacy kicks in. Intestacy is a Latin word that literally means without a will. And if you don't have a will, then it follows your genealogy. So if you're married without kids, to your spouse. If you're married with kids, then they ask, are all the kids with the spouse? If yes, then all to the spouse. If no, then half to the kids, split evenly, half to the spouse. If no spouse, no kids, then to the parents. If no parents, then to the siblings. If no siblings, and so on and so forth. And so we literally have to do genealogy when we try to figure out where things are gonna go if somebody dies without a will. Which, again, I started this off, if you are starting a family or you're even thinking about it, just get a will. If you have some assets, something worth protecting, something you want to keep away from creditors and keep out of the courts, then you're going to want to trust. And at the very least, just have a conversation with an estate planning lawyer, or go on our website. We have a free guide that you can download all about estate planning, basically explaining in layman's terms everything I just said. So if you guys have any questions, just reach out. Thanks, everyone.